So I most warmly welcome you to this afternoon session. And I firstly want to congratulate all of us on what we have achieved through this recent Supreme Court judgment and why it is like, I think this is going to be a major game changer for disability rights in the country. Because for once, a Supreme Court has not given us just individual symptomatic relief, but has looked at the entire issue of accessibility from a structural perspective, allowing us virtually to sort of redesign and rethink on the entire question. And this has happened because we were all in it together. So I'm sort of so very, very, very happy that we are all here to talk about this judgment. And because it is a legal document, we felt it may not be, it may be appropriate for us to just sort of unpack the judgment and understand exactly what the court has done. So what I am going to do in this presentation with you today is I'm going to firstly a little bit talk about what the case was about, how Rajive Raturi started the entire process as far back as 2005, got the first major kind of judgment in 2017, and the various struggles which happened from there. Then how CDS was asked to do the report, what did we do in the report to the court, and then move from there as to what is the judgment of the court. Today's session is primarily an explainer of the judgment, but I am in the last slide providing for some kind of pointers to the way forward, but we'll discuss the way forward in our Saturday session. So what this case was about, I mean, it was like as far back as in 2005, it was primarily filed, the petition was filed to enlist the power of the court, to take the support of the court, to make the government do what it had said it will do in relation to accessibility. And it kind of, in the early phases, you kept having the case listed again and again. Then you had a judgment in 2017. But one of the major things which the court kept doing was asking the various state governments and the union to report on what it is doing in relation to accessibility. And they had these various reports which kept getting filed, somewhat inadequate, sometimes incomplete, sometimes lots of states did not file at all. So they reached a point, I think somewhere into 2023, when the court and the petitioners got just tired of what was happening. They felt it was a cat-mouse game. And they said, okay, instead of like continuing to ask for these affidavits to be filed, why don't we have an independent agency, not just report what is happening, but also kind of analyze and think as to why it is happening the way it is happening. And that's how CDS came into the picture. I mean, you all are all aware of the fact that it was sometime in November 2023 that we were asked to do this. We sent our, there was a back and forth correspondence between us and the court. And in January 2023, we sort of told the court that, okay, we will do it. We'll take 6 months to do it. We will do it in a participative manner. We will be involving the disability sector, civil society organizations, persons with disabilities, law students, if possible, students of architecture, and give us the freedom to formulate our own methodology, which was done. So I don't want to spend any time on it, but it's more like you can't start from the middle of the story, hence this beginning slide is there. Then it is like, okay, what did we do in the report? I mean, we are all, everyone has kind of given their own inputs to the report, and I definitely think it's our report. But just for a recap and just to sort of make the connection between what the report was saying and what the court ruled, I am sort of saying, bringing out for you exactly the kind of things that we said very emphatically in the report. We kind of sort of said, because somewhere it was also to do with the fact that the Accessibility India campaign was like stressing a lot on retrofitting, but was not really talking as much on how are we ensuring that all the fresh facilities or the new creations that we are doing are accessible. So one of the very emphatic statements which came in the report, which was reiterated by all the organizations and individuals who kind of inputted into the report, was that accessibility means not just to redesign the world, but also to ensure that all future activities will be done in an accessible manner. Now, and this is important, that to talk about these two prongs of the right to accessibility, it's both retrofitting as well as planning for the future. We were also acknowledging the fact that retrofitting may be prioritized and progressive, in the sense of, like, you can't be sort of saying that, immediately the whole world will be retrofitted. That is as such not possible. But creation of whatever you're going to do for the future has to be for every place and has to be immediate. So that's the reason why this distinction between the retrofitting part of accessibility as well as the future creation part of accessibility was so important, because your whatever you're going to be creating for the future from today in any part of the country, for any disability, for all of, for every kind of, it needs to be an inclusive, a universal exercise. And you can't say that, okay, we will do it in the cities today, but we will do it in the villages day after, or 10 years later, or 5 years later. Both will have to be done together. So this was something which was emphatically put in the report. And it is, again, when I come to the judgment, you'll find it, this resonates in the judgment also. The other thing that one had to be saying with it, accessibility has to be ensured for all disabilities. Every disability may have different kinds of needs and requirements. So you're not just going to limit it to some impairments and leave out others. You have to talk in terms of accessibility for everything. This was another very important part of the report. And that's why, where we did not know anything better, we had those affidavits coming in from, especially for people with psychosocial, intellectual, developmental disabilities. And it was like, put in there as explicit affidavits which came in from, to be ensuring that the court as well as all other policymakers think of all disabilities and not just some. The other aspect of the report, to which I suppose there was a huge contribution which came in from all the civil society organizations which carry down, on ground investigations, which was to demonstrate the fact that when you deny accessibility, you deny other rights. You just don't deny accessibility, you deny education, employment, health, leisure, relationships, you name it, they're all there. That was another very important part of what the report was saying. Now, this is one part of what we have in the report, and this is the more technical aspect that I'm moving to. And one reason why we need to have this explainer, because what I've already said, all of you are familiar with it. It's not like, it's more, in order to have a continuity in the presentation, that one had to say those things that I've just said. The more important, or the more technical aspect of the report and then of the judgment, is primarily this connection between the statute and the rules, or between the Rights for Persons with Disabilities Act and the Rights for Persons with Disability rules. Now, what is it that the Act did in relation to accessibility? The Act made accessibility a right, and the substance of that right was incorporated in your sections. I'm okay in terms of speed. I hope I'm not going too fast. Okay, the substance of that right was incorporated in sections 40 to 46 of the Right to Persons with Disabilities Act. Now, I want you to sort of, like, I know you're all familiar with it, but just to understand the legal point. What was the scheme of the Act? I mean, I'm highlighting over here that the Act, that is the Rights for Persons with Disabilities Act, created a mandatory regime. That means it was compulsory. You have to do it. What did they do in Section 40? In Section 40, they required that rules will have to be made in relation to your Section 40 was stating that the central government, in consultation with the Commissioner for Persons with Disabilities, shall make rules which lay down the standards of accessibility for the physical environment, transportation, information and communications, including appropriate technologies and systems, and other facilities and services provided to the public in urban and rural areas. So you see that the coverage in Section 40 was for every place where you needed to make, like arrangements, you had to make them accessible. And it was not distinguishing between rural and urban. It was saying you have to make it for both rural and urban areas, but it has to be done how? It has to be done according to the rules which will be made. Now, the reason why you put it into rules and not into the act, because you require much more detail, and you may be requiring, certain a lot of technicalities to be incorporated. So if you put it into the act, every time anything has to be altered, you'll have to take it back to Parliament. That's the reason why you don't put it into the act and you put it into the rules. So this is the most important section for us, section 40, which required that these rules must be made by the central government in consultation with the Chief Commissioner of Disability. Then you have 41, which talks about access to transport. I'm not going into detail here because the important ones for us is 40 and 44, and to some extent 89. But I'm recapping the entire thing for us to have a continuity and for be able to sort of like fit all the pieces, so to say. Now, so 41 talks about access to transport and sort of says, in making access to transport, what are the various things that you will have to take into account. 42 talks about access to information and communication. 42 talks in terms of 42 talks in terms of access to information and communication technology. 43 talks about access to consumer goods. Now, this is only about, like, you're very pinpointedly saying, though you have talked about rules in 40, you are picking up specific areas and saying, these are the things that you will have to incorporate in the rules that you make in relation to these particular sectors. When you come to 44, they are saying here that once you have made these rules, it's like you will not give permission to anybody to build unless and until they are building in accordance with the rules that have been formulated. And after they have built, when they are seeking a completion certificate, they shall only get the completion certificate if the building has been done in accordance with the rules that have been made. So 45 and 46 is more about retrofitting. 45 talks in terms of the time limit for accessibility of infrastructure. That is like it gave 5 years for infrastructure and 2 years time limit for accessibility of services, which is what is 46. Both 45 and 46 also had a provision that this time could be extended for particular services or particular states if they make an application to that effect, and if for good reasons, if they want to do. I mean, if the government wants, it can give them more time. But primarily it was like, okay, once the rules came in 17, then you had to be, from there onwards, as such, the time limit started to run. Now, exactly what is the problem? I mean, I'm taking some time because there's some anxieties in relation to whether this judgment is going to make an increase in the timelines or something of that sort. So it's important for us to know it. The last section I have here, which talks in terms of that if there is any infringement of any provision of the Act or the rules and regulations, then in the first instance, you will impose a fine of, I think, 15,000 or something, or 5,000. And then it kind of goes on to increase that for every subsequent thing, it has to be 50,000, and it may increase up to 5 lakhs, which would mean that once you have made these rules, you have to obey them. If you fail to obey them, one kind of consequence could be that you are not given the permission to build. The other kind of consequence could be that you're not given a completion certificate. So this is the way in which they had made that entire regime. That is, the statute had made this. The Rights for Persons with Disabilities Act said that we mean business as far as accessibility is concerned. We recognize the fact that unless and until we make this mandatory, we really cannot get people to fall in line and obey. That was the vision of the statute. That was the vision of the Rights for Persons with Disabilities Act. So what did the rules do? and that's where the problem occurs. And so if I am at any point not clear, please feel free to just like tell me that, maybe repeat it or something. It may be easier to repeat it now, of course. If this is like you feel that to the extent I've said it's okay and you want more clarifications, that we'll handle after my presentation is over. But if there's something just like I've said it too hurriedly, or you want a clarification, please feel free to ask at this point. Okay. I'm sorry, I can't see you, so you'll have to say whatever if anybody's saying something.
So I want to ask that what is the uh, penalties for breaching the rules while they are not following the permission building and other issues?
No, see, the business of penalties, you have your section 89. I'm not asking you for asking me general
Sir,
questions. That you can ask at the end. I'm saying
ma'am,
in
ma'am,
presentation.
good afternoon. मैम गुड आफ्टरनून. आई एम सॉरी बीच में करने के लिए. एक्चुअल में हम चाहते हैं कि आप थोड़ा सा हिंदी और इंग्लिश दोनों को मिक्स करें तो बहुत अच्छा होगा, हमें सारा चीज समझ में
नहीं
आएगा.
नहीं, सही सही बात है।
जी मैम, पूरा इंग्लिश में होने से हम लोगों को काफी दिक्कत
नहीं
होगा.
नहीं, समझ में
जी
आ गई
जी
आपकी बात।
जी.
मैं ध्यान रखूंगी। मैं
ओके.
कोशिश करती हूँ कि मैं दोनों चीजों को मिला के बात करूँ। अभी तक मैंने सिर्फ जो बात करी थी, जो अभी तक किया है, वो मैंने सिर्फ इतना ही कहा था कि केस शुरू कैसे हुआ और सेंटर को क्या कहा गया। सेंटर ने अपनी रिपोर्ट में मोटा मोटा सिर्फ यही बोला था कि भाई हाँ ठीक है, एक्सेसिबिलिटी के दो हिस्से होते हैं, एक की जो पुराना बनाया उसको कैसे ठीक करना है, और एक जो नया बनाएंगे उसको कौन से नियमों से बनाना है। और दूसरा चीज उसमें मैंने ये भी कहा था कि हम लोगों ने कहा था कि ये जो एक्सेसिबिलिटी का हक है, ये सिर्फ मतलब कुछ इम्पेयरमेंट्स के लिए नहीं है, सबके लिए है, इसलिए सबको ध्यान में रख के उसको आप बनाइए। तीसरी चीज ये थी कि भाई आपको ये जो एक्सेसिबिलिटी है वो आपके सिर्फ एक्सेसिबिलिटी ही नहीं होता है, बाकी सारे हकों पे भी इसका असर पड़ता है, और सेंटर ने ये रिपोर्ट में काफी जोर से कहा। ये कहने के बाद में जो मेरी पिछली स्लाइड थी, यहाँ से मतलब यहाँ तक मैं हिंदी में इसलिए बोल रही हूँ ताकि वो सब लोग एक पेज पे आ जाएं, इसके आगे मैं अब खिचड़ी बोलूंगी। ओके, तो ये वाला जो स्लाइड था, इस पर मैंने बेसिकली सिर्फ ये बताया था कि एक्ट की स्कीम क्या है, और एक्ट में जो आपका सेक्शन 40 है, उस सेक्शन 40 ने गवर्नमेंट पर, सेंट्रल गवर्नमेंट पर ये एक ड्यूटी बनाई थी, एक ऑब्लिगेशन दिया था, एक उनका कर्तव्य था कि वो रूल्स बनाएंगे इस किस्म के, जिससे कि इन सारे एरियाज में जो है, जो आपका चाहे वो बिल्ट एनवायरनमेंट है, ट्रांसपोर्टेशन है, वो आपका कम्युनिकेशन है, उन सारी जगहों पे, उन चीजों में एक्सेसिबिलिटी के बारे में, उसको कैसे एक्सेसिबल बनाना है, उसके लिए उन पर एक रिस्पॉन्सिबिलिटी दी गई थी कि वो ये रूल्स सीसीबीडी को, मतलब चीफ कमिश्नर डिसेबिलिटी के, कंसल्ट करके वो बनाएंगे। और उसके बाद मैंने सारे बाकी के सेक्शंस जो थे उनके बारे में बात की थी कि हाँ 41, और मैंने कहा था सबसे ज्यादा इंपॉर्टेंट जो है वो 44।
Excuse me.
Yeah.
If you could speak in English. I am from Chennai. My name is Raguraman.
I will be speaking in English and Hindi mix. This is only recapping what I have already said in Hindi. I am going to do both. Okay.
Thank you.
I have already said this in English because
I'm
some people did not get it at that point. So I am only recapping it in Hindi. The whole thing is not going to be Hindi. I'll be doing Hindi and English together. Don't worry.
Thank you so much.
I'm also from Hyderabad. So I'm cognizant of the fact that I was just sort of making for a level playing field. That's all. तो अभी ओके, फिर हमने 44 का ये कहा था कि अगर रूल्स के मुताबिक अगर आपने बनाया नहीं, अगर आपका प्लान जो आपने दिया वो रूल्स के, एक्सेसिबिलिटी रूल्स के मुताबिक नहीं है, तो आपको परमिशन नहीं मिलेगी बिल्ड करने की, और अगर आप बना चुके हैं तो आपको कंप्लीशन सर्टिफिकेट नहीं मिलेगा। और सेक्शन 89 जो कि हमारे दोस्त मुझसे पूछ रहे थे व्हाट इज द पेनल्टी, आपका जो एक्ट है उसमें जो उन्होंने पेनल्टी बनाई है, वो पेनल्टी बेसिकली है कि अगर आपने एक्ट के किसी भी प्रोविजन को नहीं माना, इफ यू डोंट ओबे एनी प्रोविजन ऑफ द एक्ट, देन यू आर सेइंग दैट आपको व्हाट विल हैपन इज कि आपके ऊपर पहली बारी आप गलती करेंगे, when the first mistake you make, you can be fined up to 10,000 rupees, 10,000 रुपए तक का आप पे जुर्माना हो सकता है. And for subsequent mistakes, any time that you infringe the rules or regulations or the act, you can be fined 50,000 rupees. वहां तक कि वो बढ़ता बढ़ता 5 लाख तक जा सकता है. It can go up to 5 lakhs. This is what the scheme of the statute is. ये आपकी statute की पूरा जो डिजाइन बनाया उन्होंने स्टैट्यूट का, वो ये था. ठीक है, यहां तक अब मैंने हिंदी इंग्लिश दोनों में बोल दिया है. ठीक. Now I'm going to do, after this, every slide I will do partly Hindi, partly English. That's how. Or I speak in English and then translate in Hindi. लेकिन मैं दोनों चीजों में बोलूंगी. ठीक है. So और खिचड़ी बोलूंगी जरा. अब जो इसमें आपका जो रूल्स हैं, जो उसकी शुरुआत हुई, when we started it, we very clearly said every establishment shall comply with the following standards relating to physical environment, transport and information and technology. तो ये shall पर बहुत ज्यादा emphasis है कि shall का मतलब है ये तो आपको करना ही पड़ेगा. The very fact that you have put shall means you shall have to do it. What we then did after that, we had the harmonized guidelines of 2016, and then we had them replaced in 2021. You have 16 other guidelines and standards, and ये सब के सब जो हैं, they provide guidelines, they provide standards, लेकिन they don't tell you what is it that if you don't do, you will not get the completion certificate, or we will impose a fine, or we will kind of deny you or not give you the permission to build. कहीं पर भी जो ये स्टैंडर्ड्स हैं उसमें ये नहीं लिखा है कि क्या चीज ना करने पर, क्या चीज है जो मुझे जरूरी करनी है, और अगर मैं ना करूं तो मेरे को हो सकता है कंप्लीशन सर्टिफिकेट ना मिले, हो सकता है परमिशन टू बिल्ड ना मिले, या मेरे पे फाइन लग सकता है 10,000, 50,000, 5 लाख तक का. Nowhere at all do the standards say that. तो आप इसलिए आपने यहाँ तो शाल लिखा, लेकिन जो स्टैंडर्ड्स बनाए वो बेसिकली सिर्फ ये डिजायरेबल पे बनाए, ये गाइडलाइंस बनाए, ये वॉलंटरी है. इनफैक्ट कोर्ट ने एक पूरे पैराग्राफ में रिप्रोड्यूस किया है कि जो आपकी 2021 गाइडलाइंस हैं वो कह रही हैं टू इन्फॉर्म, टू सेंसिटाइज, टू प्रमोट, मतलब वो ये वाले वर्ब्स यूज कर रहे हैं. दे आर नॉट सेइंग दैट यू शैल, यू हैव टू, दिस इज व्हाट, वो चीज नहीं आ रही. अब इस चीज को what I want you to appreciate here is this was the scheme of the act. Act कह रहा था ये बिल्कुल mandatory regime बना रहे हैं, अगर आपने नहीं किया तो इसके ये consequences होंगे. We were saying that you have to follow this. If you don't, this will be the consequences. और जब आप rules पे आए तो आपने यहाँ पे तो shall कहा शुरू में, लेकिन when you actually made the rules themselves did not tell you clearly what is it that I have to do, what is it that I may or may not do, what is it that if I don't do, you will have imposed sanctions on me. जब आपने रूल्स बनाए तो आपने ये नहीं कहा क्या चीज है जो मुझको करनी ही पड़ेगी, क्या चीज है जो मेरी मर्जी है मैं करूं या ना करूं, और क्या चीज है जो अगर मैं ना करूंगा तो उस पर मेरे पर मतलब कोई ना कोई उसमें चाहे वो फाइन लगे, चाहे मुझे कंप्लीशन सर्टिफिकेट ना मिले. व्हाट इज दैट, वो चीज क्लियर नहीं की. तो ये हम लोगों ने जो अपनी रिपोर्ट दी थी, वी सेड कि एक मैंडेटरी रेजिम को आपने जब रूल्स बनाए, यू लैंडेड अप मेकिंग इट अ वॉलंटरी रेजिम. आपने व्हाट वाज मेंट टू बी कंपल्सरी बिकेम इन अ वे बाय चॉइस, एक किस्म का कि यू नो इन द गुडनेस ऑफ योर हार्ट, या आप जितने अच्छे लोग हैं आप ऐसे वाला कर लीजिए, हम आपको आस्ता आस्ता कह रहे हैं कि आप बदलाव पे जाइए. स्टैट्यूट ये नहीं कह रहा था, रूल्स ये कह रहे हैं. They were not matching with each other. Are we okay till here? Okay. Now, this is the most technical part of the entire presentation. And it's important to sort of somewhere understand why, which is because it is here that the court has made the entire change of what I said at the start of the presentation, कि यहाँ पर इन्होंने कहीं पर एक बुनियादी बदलाव की हमारे लिए नींव रखी है. They have laid the foundation for a restructuring of how we want to think about accessibility. अब व्हाट इज द रूल ऑफ अल्ट्रा वायरस? सी इट इज लाइक दिस कि हम ये बोलते हैं कि पार्लियामेंट और गवर्नमेंट के बीच में व्हेन इट कम्स टू द मेकिंग ऑफ लॉ, जब कानून बनाने की बात आती है तो पार्लियामेंट जो है वो सीनियर है, गवर्नमेंट को वो करना होता है जो पार्लियामेंट कहती है. It's like whatever parliament asks the government to do, the government has to act accordingly. So legislature sets up the policy. जो basic policy है वो parliament से आती है, legislature से आती है. Government जो है वो अपने rules वगैरह जो है उस policy के मुताबिक बनाती है. They have to make the rules according to the policy. They cannot be in contradiction. उसके खिलाफ नहीं जा सकते. अगर उसके खिलाफ जाते हैं तो जो वो कर रहे हैं वो उस हद तक मतलब आपके कानून के खिलाफ हो जाता है. इट बिकम्स इलीगल, इट बिकम्स इनवैलिड. तो आपको मैंने दिखा दिया इन द प्रीवियस 2 स्लाइड्स इसमें that this is what they did in the statute. They made a mandatory regime. जब हम रूल्स पे आए तो वो रूल्स जो मैंडेटरी थे स्टैट्यूट में वो यहाँ पे वॉलंटरी हो गए. तो अब प्रॉब्लम ये हो रही है कि गवर्नमेंट हैड टू एक्ट अकॉर्डिंग टू द पॉलिसी मेड बाय द लेजिस्लेचर. What they landed up doing is that which was a mandatory policy in the statute, वो एक किस्म से आपकी जब रूल्स में आए उसको आपने वो कर दिया, एक लोगों की मर्जी पर कर दिया, एक किस्म से वो आपकी मतलब लोगों की चॉइस पे छोड़ दिया कि आप करोगे तो बहुत अच्छा होगा, लेकिन ये नहीं कि अगर आप नहीं करोगे तो इसके कुछ आपको परिणाम भुगतने पड़ेंगे. That was basically the big difference which came in, that whilst the statute was saying if you don't do it, these will be the consequences. Rules जो हैं, they were not saying so. So statute ने तो बिल्कुल अनिवार्य कर दिया कि ये कुछ आपको मानना पड़ेगा. लेकिन जब हम रूल्स पर आए तो रूल्स ने आपको एक किस्म की थोड़ी सी छूट दे दी. उन्होंने कहा हम आपको मना रहे हैं, हम आपको समझा रहे हैं, हम आपको पर्सुएट कर रहे हैं कि आप ऐसे करो, लेकिन ये नहीं कहा कि अगर आप ऐसा नहीं करोगे तो ये आपके ऊपर कॉन्सिक्वेंसेस आएंगे. स्टैट्यूट ने पनिशमेंट बनाई हुई थी, लेकिन अगर आपने मुझे बताया ही नहीं कि क्या चीज है जो मुझे करनी ही है तो आप मुझे किस बात पे पनिशमेंट करेंगे. सी अब I will just want to 1 minute और in the sense कि सपोजिंग आपने कहा कि भाई आप चाहे टाइप ए टॉयलेट या टाइप बी टॉयलेट, either is okay, मतलब दोनों कर सकते हैं. या ये नहीं कहा कि type A toilet supplemented by type B toilet. You did not say that. Now, if I only make a type B toilet, can you refuse to give me a completion certificate? Because you have not said that I have to make a type A toilet. You are saying it is desirable to make a type A toilet, but you are not saying that if you don't make, and I'm just using these as examples, if you don't say you must make, आपको जरूरी बनाना पड़ेगा, तो मैंने नहीं बनाया तो आप मेरे पर ना तो मेरे को फाइन लगा सकते हैं, ना आप मुझे कहेंगे कि हम आपकी बिल्डिंग का कंप्लीशन सर्टिफिकेट नहीं देंगे क्योंकि आपने टाइप ए टॉयलेट नहीं बनाया. मेरे लिए ये करने के लिए ये जरूरी है कि रूल्स में ये कहा जाना चाहिए कि यू हैव टू मेक अ टाइप ए टॉयलेट व्हिच कैन बी सप्लीमेंटेड विद अ टाइप बी टॉयलेट, बट यू कांट जस्ट से मेक वन और द अदर. अगर आपने वन और द अदर कहा है तो मैंने जौन सा भी बना दिया ठीक है, और उसमें भी मतलब सपोजिंग मेरी समझ में आया है कि भी अगर बना दो तो अच्छा है, नहीं भी बनाओ तो कुछ नहीं होगा. If that is how you understand it, you can, because you have formulated the entire rule regime in that manner. So if now the जो rule ultra virus का ये है कि अगर statute एक चीज कह रहा है, then the rules have to act according to the statute. Statute तो कह रहा था कि mandatory बनाओ, जब आप rules पे आए आपने लोगों को परसुएट करना शुरू करा, आपको लगा कि नहीं अगर हमने सीधे के सीधे लोगों को पनिश करना शुरू कर दिया तो मुश्किल हो जाएगी. Whatever may have been the reason, I'm not onto that. I'm just talking about the legal technical thing. This is what the rule of ultravirus is, and this is basically meaning कि अगर हमने एक्ट बनवाया है तो रूल्स को उस एक्ट के मुताबिक बनना पड़ेगा, उससे अलग नहीं बन सकते. They could do this, that they could make some rules and some guidelines. That they could do, but they could not make everything guidelines. ये तो कर सकते थे कि कुछ रूल्स बनाएं और कुछ गाइडलाइंस बनाएं, लेकिन ये नहीं कर सकते थे कि सारी ही गाइडलाइंस बना दें. ओके, यहाँ तक तो जो अब इस सारी सिचुएशन में कोर्ट ने क्या किया? अभी तक मैं कुछ हद तक आपको ये बता रही थी कि हमने रिपोर्ट में क्या, what did we say in the report. Now I am sort of coming to what is it that the court has ruled, what is it that they have done, because that's what everybody wants to know. And now what I have got on this slide is something which is relatively the simpler part of what the court has done. It said that it recognizes, कि वो बिल्कुल इस बात को पहचानते हैं, they recognize कि accessibility has two prongs, retrofitting and creating an accessible future. दोनों चीज है कि आपको पिछला भी ठीक करना है और फ्यूचर भी ठीक करना है. यहां तक दिस इज द फर्स्ट, ये हम लोगों ने भी रिपोर्ट में कहा था, that court is also saying that very strongly. Then वो ये भी कह रहे हैं, the second thing that they are saying is that the right has to be guaranteed to all disabilities. मतलब सब disabilities को मद्देनजर रखकर आपको अपने rules बनाने पड़ेंगे, अपनी जो भी आप norms बनाएंगे वो सबके लिए बनाएंगे, not for some only but for everyone. They have acknowledged the various pilots which were part of the report, and they have said that if you do not provide for accessibility, then you are not just denying the right to accessibility, you are denying all other rights. And they have comprehensively narrated, okay, access to justice, education, employment, transportation, leisure sport, your right to relationships, सब चीजों का उन्होंने हमारे रिपोर्ट से रेफरेंस लेके कहा है कि अगर एक्सेसिबिलिटी नहीं देते हो तो आप सिर्फ एक्सेसिबिलिटी नहीं डिनाई करते हो और बाकी सारे राइट्स भी डिनाई करते हो. और चीज उस इसी कारण से वो बहुत एम्फेसिस से उन्होंने बोला है कि एक्सेसिबिलिटी जो है इट इज अ नॉन नेगोशिएबल राइट. आप ये नहीं कर सकते हो कि कुछ थोड़ी सी दे देंगे, इतना सा कर देंगे, हमारी मर्जी से कर देंगे. यू कांट डू दैट. You have to provide, this is like at least a base. अब मैंने यहाँ पे इसमें लिखा है कि उन्होंने कहा कि आपने अगर छत बना दी और आपने फ्लोर नहीं बनाया तो फिर आपने क्या स्ट्रक्चर बनाया? आपने एक छत बना दी बिना फ्लोर के तो वो छत टिकेगी कैसे? तो इसलिए what they have said is you have to, the government had to spell a non-negotiable content. A ceiling without a floor makes for an unstable structure. ये मतलब उनका सबसे बड़ा वो था कि आपने बड़े बड़े ऊंचे ऊंचे स्टैंडर्ड्स तो बना दिए, मतलब सीलिंग बना दी, लेकिन मिनिमम नहीं बताया कि इतना तो होना चाहिए ना. जमीन नहीं बनाई, आसमान बना दिया. और आसमान बिना जमीन के कैसे टिकेगा? अगर आप जमीन पे पाँव नहीं है तो आप आसमान को देखोगे कैसे? दैट्स द काइंड ऑफ कंटेंट ऑफ जो उन्होंने मतलब मोटे मोटे चीजें एज सच एक्सेसिबिलिटी के हक के बारे में बोली. फिर ये आगे आपका, जिसपे मैंने इतना सारा आपके साथ पहले टाइम लगाया कि ये रूल्स मैंडेटरी है कि नहीं है. गवर्नमेंट ने when they were speaking in court as well as in their written submissions, they emphasized that the rules are mandatory. Everybody has to follow them, and they emphasize on this, that point which I had shown you earlier. Sorry. I'm going the wrong way. Yeah, they emphasize on this fact every establishment shall comply with. इस पर बहुत ज्यादा एम्फेसिस था गवर्नमेंट का कि हमने जब वहां पे shall लिखा है तो हम इसीलिए लिखा है क्योंकि ये मैंडेटरी है. तो कोर्ट ने कहा कि आपकी ये सिर्फ टर्मिनोलॉजी की बात होती तो हम कह देते कि हाँ shall means कि अब चाहे इन्होंने गाइडलाइंस कहा है, चाहे स्टैंडर्ड्स कहा है, लेकिन एवरीथिंग हैज टू बी ओबेड. लेकिन हम वी कांट से दैट, हम ऐसा नहीं बोल सकते हैं. क्यों नहीं बोल सकते? जब शैल लिखा है तो क्यों नहीं बोल सकते? कोर्ट ने इसमें बताया कि हम उनके मतलब 3 या 4 रीजंस हमारी रिपोर्ट से लेकर हमारी प्रेजेंटेशंस, मतलब हमने बैठना पसंद नहीं है. Hello.
Yeah, ma'am, please continue.
So court did not accept this argument कि नहीं, it is not a, सिर्फ ये शब्दों का हेरफेर नहीं है. It is not just a question of terminology. It is not like the government has used guidelines but actually meant rules. They have said no. They have in fact used the terminology. They have tried to make it like they are making rules, but in fact have only created guidelines. And that is the reason they are giving 3 reasons for why they are saying so. They are saying that you are nowhere clearly telling us what must be followed. What is it that if people don't follow, अगर उसको वो नहीं मानते हैं तो उन पर फाइन लग सकते हैं, उनको कंप्लीशन सर्टिफिकेट नहीं मिलेगा, उनको परमिशन नहीं मिलेगी बिल्ड करने की, वो सब चीजें कहीं पर आपने बताई ही नहीं है. You have not laid down what one must be followed. फिर they also pointed to several technical inaccuracies in the harmonized guidelines of 2021. They say if there are so many, इतनी सारी अगर उसमें टेक्निकल गलतियां हैं तो हम जो चीज टेक्निकली गलत है उसको मैंडेटरी कैसे बना दें. सो दैट इज अ सेकेंड प्रूफ जो कोर्ट ने देखा कि भाई ये आपने रूल्स नहीं बनाए. बिकॉज अगर आपने रूल्स बनाए होते तो आपकी उसमें इंच भर की भी टेक्निकल गलती नहीं हो सकती. इट इज लाइक नो दैट यू विल कंसिडर आप किसी भी, चाहे वो रैंप है, अगर वो रैंप की जितनी उसकी ग्रेडियंट होनी चाहिए वो ग्रेडियंट में सेंटीमीटर्स का भी फर्क है तो हमें मालूम है ना कि उसमें सेफ्टी की कितनी कॉस्ट होती है. सो समथिंग विच इज टेक्निकली रॉन्ग उसको हम मैंडेटरी कैसे बना दें. इट्स लाइक आपने फिर बहुत सारी चीजों में जैसे बोला कि भी यू मस्ट टेक केयर ऑफ ऑल डिसेबिलिटी, ऑल एवरी काइंड ऑफ द पूरी डाइवर्सिटी ऑफ डिसेबिलिटी को मद्देनजर रख के आप ये बनाइए. और फिर यू डिड नॉट स्पेसिफाई एनीथिंग एट ऑल फॉर दीज अदर्स. मतलब आपने गोल्स बना दिए लेकिन उन गोल्स पर पहुंचना कैसे वो नहीं बताया. तो इस किस्म के ढांचे को, दिस काइंड ऑफ रेजीम, हाउ कैन वी कॉल इट ए rules regime? How can we call it mandatory? Now this, the court said, they said no, we can't accept the fact कि ये सिर्फ टर्मिनोलॉजी की, सिर्फ शब्दों का हेर फेर है. वी कांट एक्सेप्ट दैट. हम इस चीज को मान नहीं सकते. हमें नहीं लगता, हमें लगता है कि आपने सोचा कि आप रूल्स बना रहे हैं लेकिन एक्चुअली जो आपने पूरा स्ट्रक्चर क्रिएट किया वो बिल्कुल एक वॉलंटरी वाला किया कि लोगों पर छोड़ दिया. यू लेफ्ट इट टू पीपल टू फॉलो इट और नॉट टू फॉलो इट. दैट्स व्हाट यू लैंडेड अप डूइंग देयर. एंड सो I mean, once they came to that, they also concluded that what the rules are, जो मैं आपको पहले बता चुकी हूँ, the rules are ultra virus the act. मतलब जो एक्ट बनाना चाह रहा था और जो रूल्स बने हैं वो दोनों चीज मेल नहीं खाती. They don't match with each other. And because government rules ऐसे नहीं बना सकती जैसे कि जो कि आपके एक्ट के खिलाफ है, इसलिए ये रूल्स अल्ट्रा वायरस हैं. ये मतलब उसने उन्होंने उनको स्ट्राइक डाउन कर दिया. उन्होंने कहा नहीं, ये इसको हम नहीं मानते हैं कि आपने जो आप पर द रिस्पॉन्सिबिलिटी विच हैड बीन प्लेस्ड ऑन यू टू मेक रूल्स, यू हैव नॉट रियली फुलफिल्ड दैट रिस्पॉन्सिबिलिटी. ये फाइंडिंग पे वो आ गए वहां पे. उसके बाद अब वो क्या कह रहे हैं? अब वो ये कह रहे हैं, what they are asking for is that the government should, in consultation with the stakeholders and with involvement of CDS, segregate the non-negotiable rules from the expansive guidelines. मतलब जो आपने इतना सब कुछ बोला है, जो सीलिंग बनाई है, उस सीलिंग में से ये निकालो कि कौन से पीसेस से अब आप फ्लोर बनाओगे, आपका मिनिमम मैंडेटरी क्या है. ये बहुत मतलब इसमें ये बहुत उन्होंने वो बात बोली कि आप जब तक ये नहीं करोगे, सो यू सेग्रीगेट. उसको करने के लिए उन्होंने कहा आप 3 महीने में इसको करो. यू हैव टू डू इट इन 3 months. उन्होंने ये भी क्लैरिफाई किया, एंड आई वांट टू मेक दिस पॉइंट वेरी स्पेशली बिकॉज अ कॉलीग हैड रिटन टू मी, स्पेशली आफ्टर जब मैंने वो दानिश साहब के साथ में वो रिकॉर्डिंग करी थी. उसके बाद में एक एडवोकेट साहब ने मुझे कहा कि देखिए आपने व्हाट यू हैव डन is this that now they will also take more time in relation to the 45 and 46. They will say they need more time because अभी तो हमने rules ही नहीं बनाए. तो वहां पर कोर्ट ने बहुत clearly बोला है that the progressive compliance with the standard listing in the existing 15(1), मतलब जो आपने already specify किया है उसको आपने रोकना नहीं है, वो आप कंटिन्यू करो, वो आप अनअबेटेड चलो. जो आप कह रहे हो कि हम इसमें मैंडेटरी काम कर रहे हैं, आप उसको करते रहो, लेकिन उसके साथ साथ में इन एडिशन ए बेसलाइन ऑफ नॉन नेगोशिएबल रूल्स मस्ट बी प्रिस्क्राइब्ड इन रूल 15. मतलब उन्होंने दोनों चीजें बोली कि अच्छा ठीक है, आप लोग आपके मुताबिक तो आप मैंडेटरी चल रहे हो, आपका जो एक्सेसिबल इंडिया कैंपेन है उसको आप यू मस्ट कंटिन्यू अनअबेटेड. आप हमें बता रहे हो हमने इतनी बिल्डिंगें एक्सेसिबल कर दी, हम इतना और आगे कर रहे हैं, वो काम आप पूरे जोर शोर से करते रहिए। इन एडिशन आप ये बेसलाइन भी बनाइए, क्योंकि कहीं पर आप उस पे जाइए जो शुरुआत हुई कि एक्सेसिबिलिटी के दो प्रॉन्ग्स हैं, दो हिस्से हैं, आपका एक रेट्रोफिटिंग है और एक है क्रिएटिंग फॉर द फ्यूचर। रेट्रोफिटिंग का काम तो गवर्नमेंट कर रही है, लेकिन वो आप करते रहो, लेकिन और उसमें मतलब आपका टाइम, इन्होंने बहुत क्लियरली लिखा है कि आपका टाइमलाइन खत्म हो चुका है, इसलिए आप उसको जल्दी से जल्दी करो, इमिडिएटली करो, मतलब वाली बात है। लेकिन ये नहीं है कि क्योंकि हम अब रूल बनाने लगे हैं इसलिए वो टाइमलाइन भी बढ़ गई, ऐसा कहीं पे कोर्ट ने उनको उसकी इजाजत नहीं दी है। दे हैव नॉट बीन परमिटेड टू डू दैट, दे हैव ओनली बीन आस्क्ड कि यू हैव टू क्रिएट नॉन नेगोशिएबल रूल्स, बिकॉज अगर हम नहीं बनाएंगे तो जब लोग अपनी बिल्डिंग परमिशंस लेने जाएंगे, आपकी ट्रांसपोर्टेशन करेंगे, आपके दूसरे कंज्यूमर गुड्स बनाएंगे, तो यू आर नॉट गोइंग, यू विल बी अलाउड टू, आपको इजाजत मिल जाएगी कि आप उनको बेच लो, उनको बना लो, और ये काम चलता ही रहेगा, तो हम सारी उम्र फिर रेट्रोफिटिंग ही करते रह जाएंगे। इसके लिए उनका ये कहना है कि आप पहले ये रूल्स बनाइए, इनको अलग अलग कीजिए, आप पूरे स्टेक होल्डर्स के साथ कंसल्टेशन के साथ कीजिए, और फिर उसके बाद में जो आपका 44, 45, 46, 89 ये सारे जो चीजें हैं इनको आप लागू कीजिए। आप आज की तारीख में इफ यू ट्राई टू इम्प्लीमेंट देम विदाउट हैविंग मेड दोस नॉन नेगोशिएबल रूल्स, you will not be able to implement them. The court is acknowledging that and is insisting that you have to set that right. और इसको करने के लिए उन्होंने एक बोला है कि भी आप यूनिवर्सल डिजाइन का ध्यान में रखो, यू कीप इन अकाउंट कि भी जहां तक हो सके आप ऐसा डिजाइन इस्तेमाल करो जो कि मतलब ज्यादा से ज्यादा लोगों को इंक्लूड करे। यूनिवर्सल डिजाइन बेसिकली मीनिंग दैट कॉम्प्रिहेंसिव इंक्लूजन अक्रॉस डिसेबिलिटीज। उन्होंने जितने डिसेबिलिटीज, जितने इम्पेयरमेंट्स को, जिनके एफिडेविट्स हमने दिए हैं कोर्ट को, उन सबको इंक्लूड करके कहा है कि व्हेन यू आर मेकिंग, जब आप ये गाइडलाइंस बनाते हैं तो आप इस बात को ध्यान में रख के बनाइए कि आपने सबको इंक्लूड करके बनाया। फिर ये कि जैसे टेक्नोलॉजी बढ़ती है, वो टेक्नोलॉजी को ध्यान में रखकर ट्राई टू सॉर्ट ऑफ सी टू इट दैट यू आर अब्रेस्ट। और लास्ट चीज जो हमारे लिए इस पर्टिकुलर मीटिंग के लिए और जो हम सैटरडे को मीटिंग करना चाह रहे हैं उसके लिए बहुत ज्यादा जरूरी है कि दे आर इंसिस्टिंग ऑन कि यू हैव टू हैव एन ऑनगोइंग स्टेक होल्डर कंसल्टेशन, यू कांट डू इट विदाउट दैट। जो मैंने एक लास्ट, मैं आखिर में पहुंच रही हूँ, जो मैंने लास्ट स्लाइड जो मैं कहीं पर एक किस्म के, यू कैन से it is a kind of a celebratory slide for this particular meeting and for all of us together, is this acknowledgement of the court that in the report the sector has created in knowledge commons, कि आपने एक ज्ञान का एक स्रोत बनाया है जो कि सबने मिलजुल के बनाया है। उन्होंने इस बात की बहुत ज्यादा, यू कैन से there's a lot of plaudits from the court, बहुत सारा इस बात की प्रोत्साहना की है कि आपने ये एक रिपोर्ट जो है ये एक कोलैबोरेटिव एफर्ट है। it is a combination of experience और रिसर्च, कि भी आपने रिसर्च भी करी है, लोगों की एक्सपीरियंस की जो एक्सपर्टीज है उसको मिलाकर ये कॉम्बिनेशन में ये रिपोर्ट बनी है, जो आपकी हमारी जितनी स्टडीज थी, all the empirical studies we made, all the affidavits we have submitted, everything has been given a great recognition in the judgment of the court, because हर किसी ने जजमेंट पढ़ी नहीं है, तो I feel it is important, ये आमतौर पे नहीं होता है कि every single work has been footnoted, or at least largely most of it has been footnoted, but you can see that the spirit of the report has informed the judgment also. मतलब जिस एहसास से हम लोगों ने वो रिपोर्ट बनाई, वो एहसास आपको जजमेंट में जिस किस्म से वो लिखी गई है वो भी दिखता है। तो जो मेरी मतलब, क्योंकि ये जो लास्ट वाली स्लाइड मैं आपके साथ शेयर कर रही हूँ वो आज का मुद्दा नहीं है, आज हम सिर्फ ये जजमेंट को समझने की बात कर रहे हैं। मैंने सिर्फ इसलिए कि एक सोचने के लिए जैसे रख देते ना कुछ चीज, ये वैसा वाला एजेंडा है कि अगर अब ये हम अब इस जजमेंट के बाद, जजमेंट को समझने के बाद हमारा सेक्टर का, हम सब का आपस में अब आगे क्या हमारा रास्ता है, हमें क्या करना चाहिए। तो मैंने 3 इसमें पॉइंटर्स बनाए हैं। एक तो मेरे को लगता है कि जिस प्रिंसिपल से हमने रिपोर्ट बनाई थी, मिलजुल के, एक दूसरे को काम बांट के, हर बंदे का काम पूरी तरह से एक्नॉलेज करके, ये समझ के कि somebody has expertise in something and someone has in something else, we joined hands together and we created the report. And importantly, we created, all of us kept to our respective deadlines, and we finished the report in the time we had given to the court. So when everybody is worrying about, सबको चिंता हो रही है कि हम 3 महीने में कर पाएंगे कि नहीं कर पाएंगे, इस बात को भी याद रखिए कि जितनी बड़ी हमने रिपोर्ट 6 महीने में करके दी, हर जाने को लग रहा था कि we'll ask for an extension. We did not. We finished it in 6 months. So let's trust ourselves. The second thing I'm wanting you to think about is the CRPD strategy. I don't know how many of you know, but it's a fact कि CRPD जो है, जो आपका Convention of Rights for Persons with Disabilities, इसको states ने नहीं बनाया. ये पहले सिविल सोसाइटी ने बनाया था, स्टेट्स ने उनके ड्राफ्ट को रिस्पॉन्ड करके जो अल्टीमेट कन्वेंशन बनी उस पे बनी है. तो हम भी वो रूल्स के लिए भी कर सकते हैं. उसको हम एक सोचने का, दूसरी बात मैं छोड़ के जा रही हूँ, हम इस पे डिटेल में सैटरडे को बात करेंगे. और तीसरी बात मैं ये बोल रही हूँ कि हमें भी मालूम है, ऑल ऑफ अस नो द फैक्ट, इट्स ट्रू दैट द गाइडलाइंस हैव नॉट वर्कड एवरीथिंग आउट नीटली, बट इट्स नॉट लाइक दैट वी आर ऑन अ ब्लैंक स्लेट. There are lots and lots of things, like the range of guidelines we have in relation to websites, और जो हम लोगों के पास बिल्डिंग कोड में है कुछ, मतलब there are several things जिसमें कि हम लोगों का वर्चुअल एग्रीमेंट है. तो अगर हमारा उसमें मॉरलेस एग्रीमेंट है, तो हम लोग ब्लैंक स्लेट से नहीं शुरू कर रहे हैं, एंड वी डोंट हैव टू सिट एंड स्टार्ट फ्रॉम द बिगिनिंग. तो वो एक चीज को भी हम ध्यान में रखेंगे एज वी थिंक, एज वी गो फॉरवर्ड. मेरे को इतना ही कहना था. आई एम स्टॉप शेयरिंग, एंड देन आई थिंक अब हम लोग जो भी मतलब क्लैरिफिकेशंस, क्वेश्चंस, कंसर्न्स, उस पे हम जा सकते
हैं. गुड इवनिंग मैम. Am I audible?
Hi.
Yes ma'am. I want to ask you, like they put penalty of 10,000, then 50,000, then 5 lakhs. But that is not justiciable for everything. Like if you will put a penalty for a startup, so it will be too much. If you will put the same penalty on Google, Microsoft, LinkedIn, or like others company, it will be nothing for those companies. So this should be in percentage wise of their net profit or something like that.
See, when you talk in terms of a penalty, this is like getting into something. We are not quarreling with the statute, right? And we are not doing a general understanding of the court which has to impose the penalty can take into account the fact of whether they want to make it. You can say even 5 lakhs may mean nothing. That's a different thing altogether. And whether we want to amend the statute and increase the penalty, but today though we can't even put 10,000. See that, so let's not get derailed from what we want to do in terms of changing the act. We will discuss for another thing. What we are trying to discuss today is exactly how we want to implement this judgment and get into the rules that which it ensure, वो इस बात को ensure करेगा कि भी हमें ये जो accessibility का हमारा मुहिम है वो चल निकले. It should start.
Okay, ma'am.
Amita ma'am, thank you very much.
Hi Akhil, how are you?
All well, all well. Thank you very much for deciphering.
आजकल तो बोलिए.
Thank you very much for deciphering the whole judgment. Rules के लिए तो definitely we have to quickly make a committee. We should all start working on it, probably disability wise, sort of taking out what is the most essential and which can take little backstage. Yeah, and in terms of way forward, I think we also need to think about a clear implementation roadmap, that who would be involved. Government, if we leave it on the government, they'll again make a committee which is not going to work. So one thing, and second thing, a monitoring mechanism we need to put, which should be inclusive. We definitely need to have people with disabilities in the monitoring mechanism as well. And how far we can use technology, because that is the thing of today. So probably in 2016 we might not have understood or got the idea of the technology which is available with us today. So I think that also plays a very important role. Thank you very much for the time.
Akhil, I hope you are going to coming on Saturday because I want to spend ज़्यादा time आगे चलने में क्या करना है सैटरडे को निकालना चाहते हैं आज मैं बेसिकली चाह रही हूँ कि whatever anybody has not understood in relation to the judgment, you know, मुझे अपने आप पे बड़ा नाज है कि मैं बहुत क्लैरिटी से बोलती हूँ लेकिन उसके बाद I am recognizing the fact कि it is a technical judgment. Let's accept the fact. It's a legally technical judgment. तो हमें लगा कि which is the reason why it got split, you know, कि आज सिर्फ judgment को समझने में time लगाते हैं और Saturday को हम लोग ये decide करते हैं कि how we should go forward. So what you have said is important and we should break it down. I would also जब मैं Saturday को presentation करूँगी उसमें मैं थोड़ा बहुत एक suggestive खाका, you know, like कि this may be a way forward बन के ताकि we can all respond, react to it. Usually होता है कि कोई draft हो तो उस पर आगे थोड़ी मदद मिल जाती है.
True.
And we don't have time.
Yes.
हम लोगों के पास टाइम नहीं है और हम ही जल्दी मचाएंगे तो ही गवर्नमेंट जल्दी मचाएगी अगर हम लोग सीधे बैठ गए तो nothing will happen.
True.
Yeah, I think.
Thank you. Thank you.
I can see your name is first.
Hi, good afternoon, ma'am.
Good
Am I
afternoon.
audible and visible? I hope I'm audible and visible.
Yeah, you're audible. Please go ahead.
Yeah. So, ma'am, my curiosity comes out from the judgment itself, where we have seen the rules being getting ultra virus. Now the issue comes up that the matters which are already pending in multiple courts under section 40 and thereafter 40, 44, 45, 46. So where those matter will land up, because if those matters are at the final stage or the decided stage, so what can be done in that case? Because that is much more important. Because if we see it at the prior end, so the things are different, and the things that will come after the rules, that will be different. So that's my curiosity out of the judgment, ma'am. That's the problem. That
And I'm presuming you're a lawyer. Because are you?
final,
You are a lawyer.
final year, ma'am.
Okay. So, Jayant, it's like the way it works out is that whatever was the law at
Yes.
the time at which you filed the petition,
Yes, ma'am. Definitely,
the petition will be decided according to that law.
definitely, ma'am.
It can't that is not going to alter. And the very fact the court, that's why मैंने वो line खासकर पढ़ी है. They said, whatever you are already doing, you will not stop.
Okay, so that's
You
the
have to
stage.
carry on with that. We are only anticipating where things can cause trouble because it's a fact, Jayant, that when it comes to all your see, I mean, like, forget about the rest, yaar. Courts ne, आपका झारखंड का नया court बना. It is not accessible.
Yes, ma'am. Yes, definitely.
No, it is like so. This part of the judgment is to ensure that from now onwards, whatever you do, if you think you can do it without it being accessible, you can't do it. See,
Definitely.
let's sort of just segregate. लेकिन वो जो because government तो कह रही है सब mandatory है.
Yeah, definitely.
You can't go back on their own word, no? And the court has also very clearly said you have to do what you're already doing. We are not asking you to stop anything. So that's how your those cases will go. And जो हम principle बनाते हैं ना, आपका जो legislation.
Definitely, ma'am. Definitely.
Perspective, it will go in forward. It's not going to go retrospectively and saying कि
Because that was my curiosity, because how the new rules will be.
No. Whatever
the pending matters. That's the difficulty.
Not for pending matters. Not for no way.
So only for the new matters will be coming up.
It will only be because that's a basic principle. It's both in all your this thing, unless and until you explicitly make something retrospective, it's always prospective as far as legislation is concerned.
Definitely, ma'am. But my curiosity comes out because the entire rule got ultra virus. So I was like, will it be retrospective effect or what it will be going?
What rules they have made ultra virus? अगर आप वो ultra virus नहीं करते तो हमारे पास situation ये है कि we don't have anything which we can insist that people will have to put.
Yeah, definitely.
We as the Center for Disability Studies are law this thing. We are not the accessibility people. But
Definitely.
everybody in the accessibility people this thing told us that if you don't make anything mandatory, you will
Definitely.
never get the accessibility right off the ground.
Definitely.
Okay.
Thank
Okay.
you.
Now,
Thank you,
yeah,
ma'am. Thanks for your
most
input, ma'am.
welcome. Aditi.
Hello, ma'am. Can you hear me?
Yes, I can. Aditi, go ahead.
Hi. So it's only through this judgment and your report that I realized that the guideline that they're not mandatory. I'm wondering, since the time the guidelines came and up till now, how have the courts, how did nobody realize this, and how have they been implementing it then? If it's not by its nature uh, being able to be implemented, what are they
Okay.
doing?
See, what they have been doing is they have been doing a pick and choose game, Aditi. Everybody has been doing what they thought they could do. And if you have, it's like when you talk in terms of mandatory, it basically means if you fail to do it, have they denied anybody a completion certificate? Have they refused anybody permission? Have they fined anybody? No. That is the connection which was not being made, and that's the connection that is being made now. You get me? It's not
Okay.
like nobody was following it, but they were following at their will and preference, according to what they felt like doing. जो
So
उनको सही लगा, that ways.
So people were still going to the court and asking for remedies based on what they thought was
Yeah, they
mandatory.
were asking for remedies, and maybe some remedies were also being given. I am talking in terms of people not going to court. See, for everything, one doesn't go to court. If I don't go to court, without my going to court, is something being done? That's the critical factor. See, your everyday, let's say, the people who give permissions for building, the people who give you various kinds of licenses, do they sort of refuse to give them that license because of the fact that the accessibility guidelines have been breached? If you don't do that, then it is not mandatory, it is only desirable. It's only voluntary. It is left to the preference of people. That's the
Understood.
truth of the matter.
Thank you, ma'am.
Okay. Jamshed? Hi,
Yes.
Jamshed.
Sorry. Yeah, I'm a little unwell. That's why I'm not in court dress. But
No, no, you're
anyway,
absolutely
first and
fine.
foremost, congratulations on the. This is very, very important. This is. I would go a little further. I heard what you have said. I think just the fact that the rule has been struck down will have a major impact if we produce the judgment before a lower court. And they will say that, listen, in light of this, the principle has been set down now, and it is mandatory. Whenever the rules come and how it is to be implemented is a secondary issue. This is in my view. Now, this suddenly becomes very important because I don't think ever under in this legislation have they actually faced this kind of an issue. I'm talking about the governments and others that they've suddenly been faced with something saying that this is now struck down, it's ultra virus, and therefore now you have a, rules which are to be framed, but it is mandatory unless they go to a larger bench and clean that up. That's a different story. So my question to you is twofold. Number one is, have they set a time frame for the rules?
Three
Anything like
months.
that? All right, all right. And the other aspect is that uh, 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 and the matter is again listed somewhere in March, is it?
Yeah, 7th
Oh,
of March.
all right. So I think, yeah, I mean they'll have to work, doubly
We'll
shift.
have to work, Jamshed. I'm very clear on that count.
Yeah,
We'll have
yeah,
to work.
yeah.
Because
No, no, but
ultimately, the government has to take out a notification. That's what they have to do. But what
absolutely.
we want in that notification, I think that's something we have to settle up.
Correct, correct.
And
No,
I'm
no,
talking
I
about a
think
basic principle that whatever law which the government claims was the law remains the law till this time.
No, no, very, very true. But I mean, this is. Hello, can you hear me? Can you hear me?
Yeah, I can hear you, Jamshid.
Sorry, sorry.
Yeah.
No, no. So I think at least that's what I'm going to do, because some of the matters are listed in December, and we will definitely produce the judgment and say that now, in light of this, it's not a question of at their whims and fancies, or depending upon blah blah blah. No, I mean, it has to be done. How it is done, let them do it. You know, Otherwise, I mean, you know, we don't want it to be just stood over. See, because that is what the again, the government and the lawyers are damn smart. They will say, no, this is still pending. Let the Supreme Court decide. We don't
No,
want
no,
that.
no, 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 no,
Yeah.
no, 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 no. Supreme Court has only sort of, the Supreme Court has kind of listed the matter again before itself, only to ensure that the timelines that they have given are followed, that they will in fact do what they are required to do within 3 months. They have also very clearly said, once you make the rules, then you will implement the sanctions that you have. You will stop giving people completion certificates. You will stop giving them permission to build. You will impose fines. My friend in the beginning had a worry that the fines are not going to be proportionate. Abhi to ho hi nahi raha hai. You know what I mean? Imposing, let's say, 10,000 fine, but who's talking about 50,000 and lakhs? That is something that we can separately fight for, but at least let's get the thing off the ground. That's how I am seeing it.
And in this rule, is there any hint on the power of the commissioner, etc.? Or no, that is separate.
No, what they are, see, they have what we want to put into the rules. What are the other things we want to do? That's something we could maybe settle. But to say inaccessibility, what is it that we feel you just have to put in there?
No, absolutely. No, but I mean, this will.
Otherwise, it will be a lifetime retrofitting exercise if you don't start your fresh building from an accessible point. That's the thing that has to be accepted.
No, and once last statement, once it is compulsory, then, well, interestingly, you will have to give the commissioner's powers. So that's a very interesting. Anyway, we'll discuss it later. Thank you so much. Thank you.
Renu? Renu?
Can you hear me?
Yeah, I can.
Okay. I just have one question. It should be accessible to all disabilities. So, we have a number of disabilities. So, and also in terms of what I'm hearing, is the judgment largely focused on accessibility in the built environment? Is that like the major focus, physical accessibility? And when you say all accessibilities, then from the report and from the experiences, there would be a range of accessibility needs across the board. So when we write, we need to then develop a framework where we ensure that as far as possible all legally recognized disabilities their accessibility needs are considered, and then which ones of those can be incorporated as very fundamental, requiring to be addressed. But I just wanted clarification, that is the focus in this, because the term is retrofitting and cities for the future, or accessibility thinking in terms of the future. So are we largely thinking of infrastructural and built environment issues?
No. I'm sorry. I mean, because if you go back to that last slide when I was talking in terms of the principles which were guiding the court, they have very emphatically said inclusion of all. And whether, and it's in fact, they have specifically named, they are talking in terms of whether it is autism, whether it's cerebral palsy, whether it is even, what's it called? Sickle cell disease. They've talked in terms of, intellectual disability. They've spoken in terms of even ichthyosis, which ichthyosis is not even an included impairment in the list. The court has still mentioned it. So they are not at all only talking in terms of only physical this thing, but retrofitting to the extent that when you talk in terms of, see, they've in fact named, okay, for people with cerebral palsy, they want a list of scribes. For people with autism, they want accessible devices. So they have spoken about what are the other kinds of things that you require. So it's not only physical, but it is evidently at one level, physical infrastructure is like catches the imagination much more. Sort of things.
Okay.
Okay, Poho?
Yeah,
Accessibility.
good afternoon, ma'am. My
Yeah,
video is not working. Can you hear me?
yeah, I can hear you, Poho. Go ahead.
Okay, so my video is not working, but first of
I've
all,
just seen you recently, so I can imagine your face.
thank you very much for this session. It was really very enlightening and giving a very good clarity for on the what has happened and what has come out. And I also to echo like the accountability, we have to see that in our rule that we can do that. Accountability is not only the government but the other important all stakeholder should be pinned down in the rule. That is what I think. And also I think that monitoring committee will have to have the representation from the sector for things to happen. So that will be very important. Other things have been already said by other colleagues, so I'll not repeat that, but I hope and look forward for the Saturday sessions. I'm really excited, and I am sure that we all together will be able to really make a good rule which gives us the better future forward. Thanks, ma'am. Thanks again.
Thank you so much. I have accessibility training here. Please.
Yeah, good afternoon, ma'am. Thank you so very much for this session. This is Architect Pooja representing Enable Me Access Association. So one thing I just wanted to clarify here, like you said, in 3 months, we need to segregate the non-negotiable rules from the expensive guidelines that we have. I just wanted to know, does this mean that because retrofitting work is going to continue, right, as it is. So does this mean that the new permissions that will be granted, they will be withheld for 3 months, or will that also continue for specifically for the public buildings and the public spaces that are being designed, say at urban and town planning levels, or maybe any government building or any public institute which comes up? So is it that for the 3 months till we have the non-negotiables being segregated, we need to hold up for the permissions of these buildings, these designs?
The way I would see it is this, that whether the permissions come or not, they won't get the completions without this being fulfilled. But I think it's a very what's it called? It's a legitimate concern, and one needs to think this out. I can't at once give you a response as to what would one do, but it's well possible that you can ask them that at least you stay the whole matter till that happens, so that you don't land up, it is a practical problem, and you don't land up just going ahead and then setting things right. So this makes a lot of sense what you're saying. I think we'll keep that in mind.
We can keep that in mind, yeah.
And Saturday, what the way forward? This is one of the things which should be kept in mind.
Ma'am, one more thing I just wanted to quickly ask here is that you said it's going to be a collaborative effort of creating this particular rule book. So is it that only few people or organizations are going to be included, or is it open for all of us?
I would say everyone.
Okay.
That's how we did the report also. We want to change the basic system.
Okay, ma'am.
Because see, the thing is, otherwise we just believe that only we know and no one else knows, and that doesn't make sense. And the truth of the matter is this, that we don't know how much we don't know.
Yes, true.
So I would we would try to work out a mechanism by which everybody inputs, certain things. Everybody's inputs can be a part of the whole process. At least that's a moral responsibility CDS wants to take, sort of things. We make that distinction between, and we believe also, in fact, I've said it in several places, but I'm saying it also now. We haven't got the money, but we have got a money being sort of given to us by the court.
Okay.
But the money that we believe once it comes, that's what we feel it needs to be used for, to ensure that it can be made as open for. Very often that becomes a resource, becomes a resource spent. So if the resource is there, then it's possible to be using it in such a manner.
Perfect. Thank you so much.
We don't know how much we don't know, Vaishnavi. That's the fact.
Yeah, that's the fact. And that is the part which, normally creates the kind of challenges that we face.
See, ऐसा है कि I suppose एक फायदा होता है कभी-कभी, because we are the academics in this whole setup, So, and you cannot be a good scholar or a good academic unless and until you keep saying, हमको नहीं मालूम, हम सीखना चाहते हैं. We want to learn. And I feel that making this as inclusive as possible. And because if we can't ask for the government to be making for inclusion and accessibility, if we are being exclusive and inaccessible, it makes no sense.
Absolutely.
Yeah, Percy, hi.
Thank you, ma'am. Thank you so much.
Good evening, everybody. Good evening, Professor Amita. It's nice to see all of you, though I can't see each of your faces. I'll just close down my video because my bandwidth is very weak here, and I'll just stop. So basically, Renu and the others have, many others have already asked this question. My question was related to services as well and other platforms, and you have already answered that, so I'm not repeating it. Secondly, I'm a lay person as far as law is concerned, so I don't understand all the nuances of this, but I have this few questions about. One is, are we also, when we are kind of looking at the rules, are we also looking at resources that are required for implementing or enforcing these rules? Secondly, compliance, are we also considering that when it comes to enforcing, and who takes care of compliance, or is it all that is described in the act itself? And my little worry is that 3 months may be a little less time to put the rules together, considering the fact that one would need to, the CDS would need to engage with a whole lot of stakeholders to understand what are the needs basically of the community. And I think what you have done, it's a commendable job that you have brought everybody together and put together this report, and I really appreciate these efforts. So in that, following from that line, we would need to take everybody on board and do this consultation. So I'm just worried about the timeline to frame this. That's it.
Okay, Percy, let me say one thing, and I think that's something I'm saying not just to you, but to everybody else also. What we have been given 3 months for is to segregate the non-negotiable from the guidelines.
Oh, okay.
Okay, let's not put other tasks there. You have to match your task to time. And say, this is what we need to do in the first place. To say, then worrying about the fact of, okay, how are we going to ensure compliance and how are we going to see monitoring? There is nothing preventing the sector from insisting that this is the next stage which has to happen.
Okay.
It's not okay to sort of start making our work so complicated. 3 months for segregating from it's not so unrealistic. It can be done. But if See, what is going to be the challenging part? That for which there is nothing. And that's exactly what for, like, say, to, the question which Renu was raising, that okay, infrastructure accessibility, you have something, website accessibility, you have something, but exactly what are you going to do for other than these, for disabilities other than the ones who are, where you are only talking in terms of infrastructure and websites and roads and airplanes? What are you going to do there? We don't have anything. But that is where, if we kind of allot to people who are experts in that, we can work on that basis. I recognize the fact that if we try to do it all today, it may just, we may neither understand the judgment nor plan for the future. So that's why, by some chance, because we made it, the notice came out as a double meeting, we decided to split it and say, today we will just understand the judgment, and Saturday we'll plan for the future. But this is just as a first level thinking, that we need to be matching up task to time.
Okay, thanks.
Yeah, okay. Who's the person next in my list? Ashutosh.
जी, गुड इवनिंग मैम। मैं आशुतोष पांडे सत्यवती कॉलेज में वर्किंग हूँ, और ये निर्णय जो माननीय उच्चतम न्यायालय का है बहुत ही आशाओं से भरा हुआ है, और नालसार ने इसमें बहुत ही प्रशंसनीय भूमिका निभाई है। मैम, मुझे लगता है कि जो कोर्ट की अपेक्षा है कि रूल्स के तहत,
माफ कीजिएगा, थोड़ा सा आशुतोष जी अगर माइक के पास आ सकें, थोड़ा सा मिस हो रहा है।
एक मिनट, मैं कोशिश कर, मैंने ईयरफोन लगाया हुआ है, क्या आप, आई एम ऑडिबल? हेलो?
नहीं, वो उनको नहीं समझ, आपका ठीक से नहीं आ रहा, मिस हो रहा है।
Amita, we can go to someone else when Ashutosh comes.
Yeah, Richa?
Yeah, good evening, everyone. Ma'am, thanks for giving your, briefing us about the judgment, which was very helpful. I have just two questions related to the physical accessibility. And one is like, given the complex nature of the urban and metropolitan cities, which has a large number of unauthorized colonies and urban slums, and on the other side we have big high rise. Okay, so in keeping all these geographies into mind, is there anything in the judgment which caters to the need of the marginalized who are in the urban slums, because they have different a different sort of issues and concerns related to accessibility, wherein the roads, streets are very narrow, there are open drainage system, there are long a web of what you can say, tubes running around on the streets, the pipelines and all running across the streets, which make even the wheelchair, not even the wheelchair user, but the normal people inaccessible. The place becomes inaccessible. And also there are large number of unauthorized colonies in the urban areas. So is there something in the judgment which takes into account these geographies also? Because when we talk of unauthorized colonies, obviously there are large number of schemes and other things which do not apply to these places.
What is the concern, Richa? Is the concern that why do we have unauthorized colonies? Or is it the concern, what is the concern? I'm not able to clearly make out.
My concern is this, that are these type of geographies that we have in urban areas, are they also included within the
see, at one level, when you say something is unauthorized, that means it's something which is not recognized by the law, right? and yet it exists.
Yeah.
So evidently, you firstly begin from what you have authorized and you have not made accessible. Or you want to begin from that which you have not authorized and has come up. Because to say that disability is going to sort all the problems that we have, you know, in terms of equity, in terms of justice, maybe like putting a very tall ask on both accessibility as well as on disability rights. But to have your so-called authorized colonies and authorized public buildings and public buildings coming up which are not accessible. Somewhere you would have to sort it out as to which one. To be saying that, you know, irrespective of where the person with disability is, at least make things as easy for them as is possible. There is one part of the judgment which I did not deal with today because I was concentrating on getting everybody to understand the technical dimension of the judgment. But there is one part of the judgment which I think is worth mentioning now, Richa, that you're raising this issue. They have talked in terms of that, yes, we go for universal design. Yes, we go for accessibility. But there will always be still somebody who is left out. And for them, the court is saying you join reasonable accommodation with accessibility. And that's a very major part of the judgment. So possibly what you would have to look at is ki jahan accessibility nahi kar sakte, what can you do through reasonable accommodation?
Okay. Thank you, ma'am.
Excuse me.
Yeah.
I have a point, a doubt.
Ashutosh?
No, this is Raguraman.
I'm going to, are you saying something?
I want to ask you a doubt.
Yeah.
So this is universal design. When you say universal design, is it when we see universal design, for example, there should be a local thinking as well should go into that.
Absolutely.
Which is not happening. For example, a tactile pathway been just like that being implemented across India, and I don't think it is of great help to most of the people. I mean, in terms of full, complete, or a happy navigation. That is one example I'm just giving out, and there are many other examples like that. So when you talk about universal design in the clauses, if you could also add this think locally, like some terminology like that, it will be of help.
When I was saying universal design, I was just reproducing what the judgment says. Okay. But when we were saying that we are going to look at what we want to make the non-negotiable, compulsory, and what we want to make it in guidelines, I think the kind of effort that we had tried to do for the court was just to say that, you know, like, you need to work. I mean, instead of saying that we want a tactile pathway everywhere or something of that sort, or to say, you know, you have to have lifts everywhere, we don't necessarily want that. We want that the outcome should be accessible and necessarily take into account the kind of resources we have available. If we have lifts everywhere and the lift stops working, then that's it, you're stuck. But to say you first have ramp, then you have lifts is a different thing altogether. You're recognizing the fact that, okay, you know, we are a country with limited resources. And with those limited resources, how is it that we're going to include disability? I think that's the point you're also making.
Yeah. And last one.
Yeah.
So last one statement, if you will.
What you're saying.
Last one statement is the state governments, okay, when even if there is a common law abiding, the whole country comes into place and everything is there, the state governments refuses. Many times we need to go away with the state governments and see to that they bring in an order in tune with the law and in tune with the circulars and things like that. So the problem is, again, there should, when we talk about this and come up with the new rules and things, there should be a strict information to every state. It should automatically, the state should follow it up without any sort of a lobbying of the disability sector. They should immediately work on it, rather just think about and consider all those things should not happen. That is a major problem in the state level. Yeah. Thank you.
Accessibility training. I mean, I invite you to make that Google form, please, and send it to me, and we'll send it out to everybody. I think the idea is just. I'm sorry I didn't get your name, and I'm calling you accessibility training.
I'm Raguraman. I'm a professor from Chennai.
Yeah, Raghuram, I got your point. Because somebody had sent a chat message in the middle. I accept your point, and I think it's valid. I think when we start to think on Saturday as to the way forward, this would be one of the things. But I have just this one small appeal to make to. I know we are all been struggling with getting implementations done over the years, But when we are normatively thinking what we want to do, let's not jump to implementation. Let's try to make rules which can be implementable, but don't worry in terms of how we are going to get it implemented at this time. Because if you start to add all of those tasks together, then 3 months becomes too difficult. It becomes too much to do. I really want you to break tasks down. We have this basic principle in research and writing that you always match up task and time, sort of things. So I'm saying let's concentrate on the task before us. Pooja, I would be very grateful if you could make that form and send it over. Pooja has this idea of making a Google form in which people can put down their pointers of what they think would be something worth concentrating on as we get into this exercise. Whatever their suggestions are, we could then segregate them and work on that basis, but it will be very helpful to make it as what should I say, as participative an exercise as we can.
Yes, ma'am, for sure. I'll surely do that. It would be an honor to me.
Thank you so much, Pooja.
Thank you.
Sudeep?
नमस्कार अनिता जी, काफ़ी अच्छा आपका सेशन था और सबसे पहले नालसार को ही हम लोग बधाई देना चाहेंगे कि इतना अच्छा मतलब जजमेंट आया है और इतने कम टाइम में अपन ने रिसर्च किया अपने और साथ में लेके आए।
दूसरों को बधाई दे लेते हैं हम लोग, सब खुश हो जाते हैं।
जी, मेरा पॉइंट ये था मैम कि हम लोग जो है थोड़ा सा कन्वर्जेंस के ऊपर भी अगर जाएं, जैसे कि अपन ग्रीनफील्ड प्रोजेक्ट्स की बात कर रहे हैं, तो जो एनबीसी है, नेशनल बिल्डिंग कोड है, या डीसीआर है, डेवलपमेंट कंट्रोल रेगुलेशंस हैं, जिसके बेस के ऊपर में कंप्लीशन सर्टिफिकेट मिलता है और जो बाइंडिंग ही है, तो उसके अंदर में भी एक्सेसिबिलिटी के मतलब क्लॉजेस डाल दिए गए हैं। एनबीसी 2016 के अंदर में मतलब सेक्शन 13 एनेक्सर बी है, डीसीआर अभी मॉडल जो है बीआईएस ने, ब्यूरो ऑफ इंडियन स्टैंडर्ड्स, उन्होंने बनाए हैं। सो हम लोग उसको भी एक बेस मान सकते हैं, बेंचमार्क मान सकते हैं। गाइडलाइंस के अलावा हम लोग उसको भी कन्वर्जेंस में जा सकते हैं। सिमिलरली डिजिटल एक्सेसिबिलिटी में भी जैसे अपन W3 जैसी गाइडलाइंस बनी हुई हैं, तो वो भी हम लोग एक ले सकते हैं कि जैसे अभी जो गाइडलाइंस बनी हुई हैं, जितनी भी सेक्टर स्पेसिफिक गाइडलाइंस है, मिनिस्ट्रीज की गाइडलाइंस है, वो सारी की सारी जो जजमेंट में भी आई है, ये वाली बात की कोहेरेंस नहीं है उनके अंदर में। कोई गाइडलाइंस कुछ बोलती है, कोई कुछ बोलती है। बट ये जब एनबीसी और इनको हम लोग मान लेते हैं, क्योंकि ये तो अगर अपन बिल्ट एनवायरनमेंट की बात करते हैं, तो जो आर्किटेक्ट हैं, टाउन प्लानर्स हैं, या जो इंजीनियर्स हैं, या ठेकेदार हैं, वो इसी को ही सबसे ज्यादा समझते हैं। बेसिकली हमारे हार्मोनाइज गाइडलाइंस को है उसको थोड़ा सा कम समझेंगे, बस इस पर समझेंगे, क्योंकि इसमें फायर फाइटिंग भी आ जाती है, आपकी इमरजेंसी इवैक्यूएशन भी आ जाती है।
सुदेश साहब, हमने जो मतलब कोर्ट को सजेशन दिया था ना, जो हम लोग उनसे कह रहे थे, हमने उसमें नेशनल बिल्डिंग कोड को कहा था कि आप इसको मैंडेटरी कर दो, हमने कहा था। उन्होंने मानी नहीं हमारी बात। उन्होंने कहीं पे लगा कि अगर एक तरफ पे आप कह रहे हो कि गवर्नमेंट ने मैंडेटरी नहीं बनाया तो इसलिए इसको आप स्ट्राइक डाउन कर दो, दूसरी तरफ पे आप किसी चीज को कह रहे हो कि इसको आप मैंडेटरी कर दो, तो हम कैसे करें? उन्होंने वो लाइन ली है, लेकिन हम लोग उस चीज को पकड़ के आगे चल सकते हैं। आपकी बात बिल्कुल सही है।
जी। और दूसरा मैम, हम लोग जो है मतलब अभी इंटेलेक्चुअल एंड डेवलपमेंट डिसेबिलिटीज के लिए, जैसे कि इसमें भी आया है डिसीजन में, और डेफिनेटली हमारा आया है इसके अंदर में, कि इनकी एक्सेसिबिलिटी के लिए भी काफी कुछ करना बाकी है। और इसके लिए बेसिकली जैसे अभी आप कह रही थी कि सभी लोग सब जानते भी नहीं है कि क्या क्या चीजें जरूरत पड़ती हैं। बहुत लिमिटेड चीजें हैं कि क्वाइट एनवायरनमेंट होना चाहिए पर्सन्स के लिए, या अपने पिक्टोग्राम्स के अंदर में हम लोग साइनेज दें, बहुत बेसिक चीजें हैं। बट इसके अंदर में थोड़ा सा ब्रेनस्टॉर्मिंग करके हम लोग आईडीडी सेक्टर्स के जो बच्चे हैं और जो एडल्ट्स हैं, उनके लिए हम लोग कुछ करें।
नहीं, दैट्स आई डेफिनेटली फील कि वो एक सेट ऑफ लोगों को उसकी रिस्पॉन्सिबिलिटी लेनी पड़ेगी। मतलब हम अगर सब लोग अपना अपना हिस्सा बांट लें ना कि कौन क्या देगा, तो हो जाएगा। अगर हम लोग सब कुछ करने की कोशिश करेंगे तो कुछ भी नहीं होगा।
नहीं, हम लोग परिवार की तरफ से मैम हम लोग कर लेंगे, जो परिवार एनसीपीओ है
परिवार बड़ी मतलब प्रॉब्लमेटिक सी चीज है, हम दोस्ती में चलेंगे। हिंदुस्तान में परिवार बहुत प्रॉब्लमेटिक है, लेकिन दोस्ती चलती है।
नहीं, परिवार ऑर्गेनाइजेशन की बात कर रहा हूँ मैम मैं।
हमें नहीं, मैं आपको रिलेशनशिप्स में कह रही हूँ कि दोस्ती की रिलेशनशिप जो है वो ज्यादा ताकतवर है।
राइट, एब्सोल्युटली एग्री, थैंक यू, थैंक्स।
शिवप्रिया।
Hi, ma'am. Good evening. Thank you for this session. I'll keep it short. So, I just wanted to understand if this judgment covers only business organizations, or does it also cover educational institutions and residential complexes, etc., ma'am?
It covers everybody. It's like it's not kind of segregated that it's covering this or not that. It's just saying because all that the your rules so to say cover, they have also covered. They have not done. They've not gone there. They just said principle wise, this is what you need to do.
Okay, so maybe my follow-up question is maybe this is from an implementation perspective, but I had this in mind from long time. So, is there a framework that government or the judiciary is putting in place to check the accessibility of infrastructure or for the digital assets, or is it that partner organizations that do it for the government?
We'll have to think about it. See, the thing is, somewhere you can't put the cart before the horse. If you don't have norms, what are you checking in terms of implementation?
Yeah.
Compliance तो आप तब check करोगे ना सिवा. Once you have the rules, so you have to create the rules before you study worry about compliance.
यस मैम बट एटलीस्ट जो रेट्रोफिटिंग का काम अभी चल रहा है उसका तो मतलब कंप्लीशन सर्टिफिकेट वगैरह के बारे में हम बोल रहे थे ना तो वो कौन करते हैं
retrofitting is something that largely the government is doing, right?
Okay.
So they have their access audit, they have way they go forward with it, they are giving their whatever stamp of approval. That's how it's operating. And everybody recognizes the fact that retrofitting is always like it is a compromise. It is never going to be like giving you exactly all that you want.
True. Yes.
That is the, so one has to keep these two separate. And to worry about compliance before knowing what you have to comply is really putting cart before horse.
Oh, yeah.
Okay. Alamelu.
Okay, ma'am. Yeah, hello, Professor Amita. Thank you so much for this talk. I could not join from the beginning because I had some other tasks to complete at the university. And having worked in...
Maybe it's recorded so you can share the recording.
Pardon?
It is recorded so you can always listen to whatever you
miss. Yeah, sure, I will. The term non-negotiable to me is quite disputable term. Because when we start listing out non-negotiables, and that might put us in danger because what I might think as non-negotiable might not sound as non-negotiable to other disabled person. So in spite of all that, I have a couple of suggestions. One is that when we talk about website accessibility, many people feel that there is a complete web accessibility, but all the apps when they begin, they are more print accessible, more accessible for people with print disabilities. But gradually, as the upgradations come, they're not accessible, right? And that's one problem. The other problem I do see often is visual capture. Audio capture is missing. While the whole website might be accessible, but the entering inside that website itself poses problems. So I feel maybe under the list of non-negotiables, one should be that audio capture must be made mandatory. That's one. The last point I have is the last point. Along with two-pronged strategy that you have, creation of accessibility and retrofitting, I would like you to add maintenance also. I said that I have worked on ground with students with disabilities in my previous workplace. And I know once the institution retrofits or creates facilities, there are no funds to maintain those facilities. Let's say, for instance, a broken ramp. Yeah.
I think that's a very valid point. I think it makes sense to your other 2 points. I'm sort of like whole business of non-negotiability. I think we will discuss in the Saturday meeting. But your third point, I definitely think that makes a lot of sense to think of it as a package deal. I agree with you. Makes a lot of
Thank
sense.
you, Professor. Yeah, and also officers may be made accountable. That would be a great help, basically. Yeah.
Irfan Saab, somebody is waiting in the lobby. Can you let just enter, get her to enter? Roma Bhagat. Okay, Anugraha.
Hi, thank you. I just wanted to understand. So, the implementation of the RPWD happens on a state level, right? The states define these rules and then implement them. Is that correct?
No.
It's at a central level. So, when the
The first rules
non-negotiable.
come from the center.
Okay, so when you're making the segregation of the non-negotiable
It
rules,
is done at the
it will be
regional level, yeah.
nationally applied.
Yeah.
Right? Okay, yeah, just wanted to clarify that. Thank you so much.
Okay, Ashutosh.
यस मैम सॉरी नेटवर्क का थोड़ा मैम
कोई बात नहीं,
डिस्टरबेंस है
अब
यहाँ
आप
पे
आई थिंक अब तो आप क्लियर बोल रहे हैं, चलिए।
जी मैम हेडफोन मैंने हटा दिया तो सबसे पहले तो मैम मैं कॉन्ग्रेचुलेशन कहना चाहूँगा नालसार को बहुत बढ़िया रिपोर्ट सबमिट किया है आपने और माननीय उच्चतम न्यायालय का बहुत बेहतरीन फैसला आया है। मुझे लगता है कि मैं बहुत शॉर्ट में कुछ चीज़ें रख रहा हूँ और ये सुझाव के तौर पर ज़्यादातर है। एक तो रूल 40 को ज़्यादा समझने की ज़रूरत है कि कोर्ट की अपेक्षा क्या है, क्योंकि वहाँ पर लिखा हुआ है सबमिशन ऑफ एनुअल रिपोर्ट बाय CCPD। तो इसको बहुत बारीकी के साथ समझना होगा, क्योंकि गवर्नमेंट के पास 101 और 102 दो एक्ट में सेक्शन है जिसके थ्रू वो रूल बना सकते हैं, केंद्र सरकार और राज्य सरकार। तो रूल 40 को समझने की ज़्यादा ज़रूरत है। और दूसरी चीज़ है मैम कि ये बहुत ही महत्वपूर्ण कार्य है, तो मुझे लगता है कि इसको हर जन तक पहुंचाने के लिए खासतौर पर हायर एजुकेशन में UGC को ये काम दिया जाए कि वो अपने प्रत्येक इंस्टीट्यूशन को भेजें और थ्रू एकेडमिक काउंसिल उसका रिपोर्ट मांगे डिटेल में कि आपके यहाँ क्या क्या दिक्कतें हैं और आप कहाँ कहाँ प्रॉब्लम फील करते हैं। और अंतिम बात मैं ये कहूँगा मैम कि जिस तरह से रूल 15 को कोर्ट ने महसूस किया कि वहाँ पर दिक्कतें हैं, वो एक अनुशंसात्मक निर्देश लगते हैं, इसी तरह से पूरे रूल में देखने की जरूरत है। जो 2017 में रूल आया अस्तित्व में, उसको देखने की जरूरत है कि प्रथम दृष्टया ये स्पष्ट होना चाहिए कि ये रूल है और इसको लागू करना मैंडेटरी है, ये नीति निर्देशक तत्वों की तरह नहीं हो, ऐसा होना चाहिए। मुझे लगता है कि क्योंकि आपके ऊपर एक बहुत बड़ी रिस्पॉन्सिबिलिटी है और सरकार के साथ मिल करके आपके कंसल्टेशन से वो सारा रिकमेंडेशन अपना भेजेंगे जो संशोधन है 7 मार्च तक। मैंने जजमेंट पढ़ने का कोशिश किया था मैम, तो बहुत महत्वपूर्ण है। यही कुछ छोटे छोटे सुझाव थे। थैंक यू सो मच मैम।
आशुतोष, मैं सिर्फ एक बात कहना चाहती हूँ आपसे कि इस वक्त जो हम काम कर रहे हैं वो सिर्फ रूल 15 पर कर रहे हैं।
ओके ओके।
अगर हम लोग सब कुछ करने के, मैं बार बार सभी को कह रही हूँ कि हर प्रॉब्लम को सॉल्व नहीं करने की कोशिश कर रहे हैं, सिर्फ रूल 15 पर गौर करेंगे। हमारे पास 3 ही महीने हैं, लेकिन ये हम जरूर कर सकते हैं कि हम लोगों का अगर ऐसा एक जुड़ाव बन जाए तो रूल 15 पर हमको रुकने की जरूरत नहीं है, लेकिन शुरू तो रूल 15 से ही होगा। और ये जो 3 महीने का समय है उसमें हम रूल 15 पर ही गौर करेंगे, क्योंकि अगर हम हर चीज को ठीक करने लग गए।
नहीं, समझ रहा हूँ मैम, समझ रहा हूँ। तो मैम मैं ये
हर किसी को ये इल्तिजा है एक किस्म की भाई कि मतलब मुझे मालूम है कि बहुत सारी दिक्कतें हैं।
यस मैम, यस
लेकिन सब दिक्कतों को अगर हम सॉल्व करने लग गए तो जो एक छोटी सी दिक्कत ठीक करने लगे वो भी नहीं हो पाएगी।
नहीं, वो बहुत बड़ी दिक्कत है मैम, रूल 15 को ठीक होना बहुत जरूरी है।
इस वक्त हमारा जो सारा जो तवज्जो है, जो सारी गौर कर रहे हैं हम लोग, वो सिर्फ रूल 15 पे।
तो मैं मैम ये चाहता हूँ कि जो ये 3 महीना है इसमें अगर हम आपको डिटेल में कुछ भेजना चाहें, अगर मेल करना चाहें तो कोई ऐसा जरिया है?
वो पूजा जो एक फॉर्म बना रही है, वो फॉर्म हम लोग सबके साथ शेयर कर लेंगे। उस फॉर्म में
एक ईमेल आईडी भी हो मैम कि अगर कुछ डिटेल में लिखना चाहें तो आपको भेजा जा सकता है।
हमारी ईमेल आईडी जो नालसर की है वो sac@nalsar.ac.in।
यस मैम।
सुप्रीम कोर्ट एक्सेसिबिलिटी कमेटी को हमने सैक बनाया हुआ है, sac@nalsar.ac.in। इस पर आप ईमेल लिख सकते हैं।
ओके मैम, थैंक यू सो मच।
So are we all?
I'll just take a moment, ma'am, to speak to you for a minute. I'm Dr. Suman. Yeah. First of all, thank you so much, ma'am, for making us a part of this project. There's only one point which I had, and I think some of these uh, speakers have already said is about the whole issue of compliance or how can we ensure. I understand it's a latest step, but in that entire rules that we are planning to propose or the guidelines, a kind of the annual report mechanism, can that become a part of that framework? So at least one mechanism that we are trying to push, because
Suman, I'm not, see, I'm saying it to everybody again and again. I'm not denying the importance of compliance, nor am I denying the importance of monitoring. But I'm saying compliance and monitoring always come after. First, let's see what is it that we want implemented. Then let's see how we want it implemented. Let's not jump the gun. Because, see, the difficulty is this, we have only 3 months. If one doesn't discipline oneself and say, okay, this is the only thing we're going to stay focused on, we will all get into big time trouble. I mean, I'm sorry, but I have to tell, hold your horses, keep your ideas in place. We will not give it up. We'll come back to it, but not at this time.
Sure, ma'am.
Yes, there is a recording, Mary. Okay, Ahuti.
Thanks so much, Amita. Yeah.
Yeah, there is a recording. We knew you'll get late. That's why.
But Amita, huge gratitude for the work you have done. Huge gratitude.
I mean, I'm so I've been saying it to everybody. I'm so thrilled that the court has done that kind of hugely footnoted, recognizing judgment.
Right.
Because we did it like a team. They have written a judgment for us, which is reflecting the spirit in which the report was written. And then that is something for which I have real gratitude.
Thank you. I look forward to the recording.
Yes. I mean, we'll make the recording.
Saturday's meeting. Yeah.
Yeah.
Thanks.
I'm not sure. Are these just names coming as such, or people have raising hands? I was just calling out, thinking that this is people raising hands.
At the moment,
I think, we are done. There is no more hands raised.
That is great. That's great. And we've done it within time, and in fact, little before. So everyone, we look forward to Saturday. Saturday is going to be that way, is more problematic in the sense that's wherein, but put your thinking caps on and we'll sort of brainstorm through and see what's the way forward. And I think as a sector, we can be truly proud that we have done something in current day India, which has not been done by too many people. So we can really be proud.
Thank you so much, ma'am.
Thank you
so much,
for the
ma'am.
leadership,
Congratulations.
ma'am. Thank you for the leadership. Thanks.
Bye, Amita Di. Take care.
Bye.
See you Saturday.
Bye, everyone. Bye.
Bye, Professor Amita. Everybody, bye. Take care.
Okay. We'll make the recording available, like we made the invite, and then I think you share it all around as much. We also have a YouTube. Nalsar has a YouTube thing where it will be put up. That my IT team will handle. So we'll just go ahead and do that. Okay. I'll have a chat with them and we'll do it as quickly as possible. ठीक है. चलिए साहब. Salam. Bye bye.
Ma'am, may I share the Zoom link with others so other stakeholders can also join from the persons with disabilities community? May I share the joining link of Saturday with
Please, absolutely. Because we absolutely, let me say it again, जितने ज़्यादा लोगों को share करिए, हमारे को बिल्कुल suit करता है. Absolutely. The report as well as the recording, everything. It's like, this is not an exclusive exercise. This is an inclusive exercise. Very, very clear on that. Okay. Thank you so much, everyone.
Thank you so much, ma'am. Thank you so much, ma'am.
Let's meet on Saturday.
Sure, definitely, ma'am. Definitely. Thank you. Thank you, ma'am.
Thank you, Amar. Bye-bye. Bye. Bye. Woo. Yes, thanks. Asli, thanks so much. I mean, Vaishnavi has kind of pulled my ears, but thank you so very much for both of you. I mean, you've made it amazing. I mean, we're really very thankful to you. Thank you so much. Saurav, and what's your name, Ma?
I'm Dr. Renuka Ramesan.
Thank you so much, Renuka and Saurav. I'm really, really grateful to both of you because that's what makes for. And even as we go out, into the world, it will be accessible to so many more people. Really grateful. Thank you so much.
Thank you.
Thank you,
Thank you,
Vaishnavi,
ma'am.
for pulling my ears.
Thank you, ma'am. Thank you.
Thanks, Amita.
Ma'am, do you remember me? I was a part of Center for this. I visited to Nalsar. You, I have done an internship there.
When?
Uh, in 2013, I was with you. I was
Oh,
on a wheelchair.
uh-huh,
So,
uh-huh.
and with the center, I have done my. That was my first visit with train. I was in fear that how I will travel to Hyderabad from Uttar Pradesh. From AMU, I have been there.
Wow. Yes, yes, I now remember. I mean,
फैजान साहब ने वो एग्जाम नहीं
अब
करवाया
मेरे
था
को
मेरा.
याद आ गया आपने एमयू बोला ना तो याद आ गया
हाँ 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 वो है. Thank you, ma'am. Thank you for all the
चलिए साहब
insights.
शनिवार को मिलते हैं बाय बाय
Sure, ma'am. Sure, ma'am.